employees for two reasons. Number one, if from dismissal right until decision it takes only 3 months, the maximum back wages the employee will get will be 3 months. Because it takes such a long time, he can get 24 months. But for me, the bigger advantage of the delay is, the longer it takes to go to court, the more difficult it is for the employer to discharge the burden. Would you agree with me on that? You know why? Let's say if I dismiss someone today and we're in court in 3 months' time, you will remember exactly what happened when I dismissed. But in 2.5 years, in 3 years' time, not easy. It's not easy. And don't forget, when you're in court, like I said, you will be questioned by the employee's lawyer. Very formal, you go to court, you take the oath, you go to the witness stand, then you'll be questioned by the employer, you will be questioned by the employee. And I have seen, lawyers do a very good job of it. That's their job. So the delay makes it difficult for the employer to discharge the burden of proof. The fourth advantage, cost. The fees. To file a complaint under Section 20, how much does an employee need to pay? Free. In fact, I'm told in the smaller towns, right, when you go to file a complaint with the IR department, they sympathize with the employee, they offer some coffee, tea and some biscuits. So if not anything, at least you get a snack, right? But then if you go to court, first question, do you need a lawyer or not? Thank you for giving me that answer, but actually that's the wrong answer. You can do it on your own. However, normally you would probably feel that if the company is represented, I want to increase my chances, so I want to have a lawyer, right? So lawyers, do they charge or not?
Yes.
Have to lah, right? Others how to survive. So, but you have a rather you have got lawyers who do work for employers like Monchong and myself. We only represent employers. And you have lawyers who mainly only represent employees. And there is a sort of a play with the system that lawyers for employees normally do. Which is, you know what? They say, I don't charge you any fees. But if you win and you get that award of back wages and so on and so forth, I will take a percentage. So this means an employee, to play this entire game, he doesn't have to take out anything up front, potentially. If he wins, share with the lawyer. Right? Now, maybe you might be thinking, why is it that, for example, Onchong and myself, we only do work for employers? Why don't you represent both sides? I think it's a little bit about credibility, in the sense that, you see, if you're specializing in this area, you are in court quite often. So, in each court there is a dedicated, they call it chairman, a judge. There is a dedicated chairman who will be there typically for about 3 to 5 years before they get promoted or retire or so on and so forth. So if you are in court regularly, you will get to know the judge will get to know you. So I give you a situation. So let's say I'm before Mr. A. So I say, Yang Arif, I am representing the employer in this case. Very straightforward, Yang Arif. Company issued a transfer order. There is a provision in the clause of the contract allowing for transfer. Employee refused to transfer. That is a breach of contract, Yang Arif. So therefore the dismissal is fair. Next case, before the same judge, Mr. A, Yang Arif, I am representing the employee. In this case, Yang Arif, the company issued my client a transfer. But you know, Yang Arif, I mean, a company cannot just suka-suka transfer lah. The judge also look at me and said, wow, this guy daman, macam ni pun boleh, macam ni pun boleh. So, you know, you sort of, it's a bit, you don't want to go there lah, right? So, the point I'm trying to make is the cost for employees to go all the way to court can even be zero, right? The last advantage, and I'm wary of my learned friend Hong Chok being here, this is my opinion, I don't know whether he shares this with me. It is my view that many judges have a pro-employee mindset. My opinion is that more judges are pro-employee compared to being pro-employer or being neutral. And you know what? I've sat and thought about this long and hard to find out why is this the case. And this is my opinion. I really think that it is a normal human characteristic where you do not have an interest in an outcome between two parties. The normal human characteristic is to gravitate towards the underdog. You know, and I can share with you, for example, when I watch a football match, I don't support Manchester United. So when I watch Manchester United play, I automatically support the other team. You know why? Because Manchester United won so much. You know, it's like I want the smaller team to win. Right? So the last year and a half I've been having a good time watching United. But likewise, put yourself in the shoes of a judge. What do they see? In the blue corner, employer A. The larger you are, imagine Petronas, revenue of billions of ringgit. And in the red corner, poor executive earning 2,800 ringgit. Automatically, I think they tend to gravitate a little bit more towards the employee. And in my opinion, there are some judges who are crazily pro-employee. When I see when you get a case is referred to court, you will get a court number. Sometimes I look at that first and I call my client and say, this court, even if I fight like a gladiator, I'm going to lose. So either you want to lose here and we take it up on appeal, or we will try and settle. Right? That is just my view. But the point I want to make is, if you look at, this is the system. Our system in Malaysia is such that you have all of these advantages. So what is the conclusion? Honestly, if you ask me, the laws and the advantages that you have for an employee, if any employee is dismissed, you must be crazy not to file a complaint. Because belum cuba, belum tahu. Sekali menang, hari-hari mau. You see, the point I'm trying to make is, and even though my dismissal was perfectly fair, doesn't matter. I can file. Right? Go to court, goyang kaki, I shake my legs, you have to prove. The longer it takes, better. Can get 24 months. I hope the employer's witnesses cannot appear. And this has happened. I'm doing a case right now. My client is a French company. The guy resigned and is now based in Ivory Coast. He is absolutely crucial witness because the dismissal was for performance and unfortunately no documentation. So we asked him to come. He said, yeah, okay, I can come. I want a first class flight ticket from... The cost of bringing him here would be about 40,000 ringgit. So my client is asking, what do I do? And I'm saying, listen, we need to get the guy because if he's not there, you cannot justify the dismissal. Right? So, the delay, more award, chances of you getting your witnesses become more difficult. And I can tell you, some people say, but if the witness don't want to come, there are cases where you can identify the witness, you can call the witness, but they do not want to come. So, yes, the law allows, I'm sure you've heard of the term subpoena. You force the witness to attend. But let me tell you, the reality of the situation is this. So imagine this is the phone conversation, yeah? So as a lawyer, I would say, I need to get this guy, and then my client says, but he's resigned. Can you get in touch with him because we need him as a witness? Okay, so HR calls up. Hey, hi, Mr. A, how are you doing? Good, good. Hey, you remember 2.5 years ago, remember that guy that was working for you, the executive? Yes. Remember you dismissed him because his performance was not good? Yeah, I vaguely remember. Okay, so he's now filed a complaint, he's gone to court. So, my lawyer says, I need you as a witness. Can you come up? No. That's a conversation, right? So, okay, then they tell it to us, we get a subpoena. Force him to come. So now when he gets a subpoena, he has to attend because otherwise, it's a criminal conviction. You can potentially be jailed for that. But look at the mindset of that guy. Oh, so I said, I don't want to come. You want to subpoena me, is it? I'll come. So now when he comes as a witness, he's no longer very friendly with the employer. So when I ask him a question, for example, so this guy was under you, right? Not performing very well, right? Actually, his performance okay, my boss said I These are the realities. Because you're inconveniencing them. And you force them. A lot of times you can't even contact them. That can happen. And then finally, you might end up in a court where the judge is more pro-employee, so your chances are infinitely higher. Right? So if you look at all of this, I think it is fair for me to conclude that if you look at the laws and the processes in which the laws are applied, everything is stacked towards the employee. That is a given. We have to accept that. So what is there for us? What can we do? Honestly, I think I can only provide two solutions. The first solution, you have to improve your knowledge. You need to understand how to manage a dismissal properly. Right? Second solution is what IHR is providing, insurance. Because you go to court, you lose, at least you can claim $100,000. You can't change these things. I mean, you want to change these things, you use Wawasan 2020, like you have to change the parliament and all of that for them to bring in a new law. It's not going to happen overnight. And perhaps maybe I just take another 10 minutes to talk to you guys on dismissal for performance. Because I think that is the area where most employers are very vulnerable. I think the statistics